Good morning to everybody. And let me start by saying that the resolution announced by the Honorable Chief Minister in the Assembly yesterday is in keeping with multiple efforts of various leaders with vision and foresight and national um, instinct for growth, national pride over the years. In the most proximate analysis, it is driven by the historic Supreme Court judgment of April 8th, 2025, where several aspects of the role of the governor, of the president, and of the interaction between elected legislators, parliamentarians, uh, ministers, governments, and ceremonial, to a large extent, heads of state, like governors and president, should be properly understood. For just 1 minute, I want to stop and talk about the important aspects of this judgment of April 8, 2025. First, that in a parliamentary democracy, real power lies with the elected representatives, and no governor can indefinitely withhold assent to bills or obstruct the legislative process. Second, it removes some lacunae in the procedural interpretation of the Constitution, where there were no timelines specified, and so the nature of either pocket veto, which is holding on to a bill doing nothing, or absolute veto, where without assigning reason or cause or any interpretation or note, bills are summarily rejected. These, it said, are not within the ambit of the Constitution or democracy. Third, in an extraordinary exercise of the Honorable Court's powers under Article 142 of the Constitution, stating that the actions of the Governor of Tamil Nadu was lacking in bona fides, it invoked its power to consider the bills deemed to be signed on the day they were presented to the Governor's office after being repassed by the Assembly. This is extremely important because it is a first of its kind in India under the Constitution, where bills have been deemed to be signed because of a lack of faith in the bona fides of the authority who ought to have signed the bills when presented. Finally, I would say, as I said then, it marks a remarkable victory for the Chief Minister, who had both the magnanimity and the sagacity to pass all the 10 bills again, even though 2 of them were passed by the previous ADMK government, not this current DMK government, and including the first one, which renamed the Fisheries University as the Selvi J. Jayalalitha Tamil Nadu Fisheries University. And because of that consistent approach, in some sense, enabled the Honorable Court's interpretation. I say that this was the proximate reason, but I want to just give a bit of history so that everybody's on the same page. The issue of center-state relations and the issue of the role of the governor has come up multiple times, as in fact mentioned in the Honorable Court's judgment, which is extensive and hundreds of pages, which I'm sure some of you have read. So the first time it actually was contemplated was in the 1960s. In 1966, as the Honorable Supreme Court mentions, the first Administrative Reforms Commission was established by the Ministry of Home Affairs. And as the judgment mentions, it was in light of the fact that what had been a monolithic political structure of India for the large part, that is, the same party continuously controlled or got elected and therefore ran the government of India as well as most of the states, and therefore there was not as many variances because it was one party that was at the center at most of the states, and therefore they just, for party reasons, they seemed to get along, or because the ideology was the same, they seemed to get along. That was starting to fracture as regional parties and other non-Congress at the time, obviously we all know which party we're talking about, governments were starting to come in the states. So the first instance actually was the first Administrative Reforms Commission constituted by the Ministry of Home Affairs of the Government of India, of a Congress government, in the year 1966. Subsequently, in the year 1969, the state of Tamil Nadu announced and constituted the Rajamannar Commission to go into these issues. The report was issued in 1971 and it was tabled in the House in 1974 by the then Chief Minister of our state, Thiru. Subsequently, in 1983, the Government of India established the Sarkaria Commission to also look into the issue of union-state relationships, the roles of governors, presidents, etc. And that issued a very clear report, including very many guidelines for the timelines to be considered when presented with bills. Following that, in the year 2000, in the NDA government under Thiru, there was a national commission to review the working of the Constitution, which was headed by Justice Thiru Venkatachalaya, and that committee also made a series of recommendations across a broad spectrum of the Constitution, but also relating to the role of governors relative to the legislatures, the role of the President, the notion of withholding or approving bills, etc. And finally, in this vein, at this point, our Chief Minister has now constituted a commission under the leadership of retired Supreme Court Justice Thiru Joseph to go through this, with members being the respected former senior IAS officer Thiru Ashok Vardhan Shetty and the former Vice Chairman of the Planning Commission of Tamil Nadu, Thiru Naganathan, the famous economist. So it is worth noting, before I go into our commission, that in this judgment, in paragraph 132, the Supreme Court observes a finding from the Justice Poonchi Commission of 2007. Did I miss the 2007 commission? No, there was a commission 2007. So I said the first Administrative Reforms Commission, MHA, 1966. Government of Tamil Nadu's Rajamannar Commission, 1969. The Government of India's Sarkaria Commission, 1983. The National Commission for Review of Working of the Constitution, NDA government, year 2000. And then I forgot to mention the Poonchi Commission, which was the UPA government, 2007, established under the chairmanship of Thiru Justice Poonchi to also look into these issues. And so in some sense, this is the sixth attempt at looking at these issues. But the Supreme Court's judgment, which covers all of these attempts, makes a very valid point, and it quotes from the Poonchi Commission's report. It says, and let's put a preface on this. The office of governor has an inherent conflict in the Constitution. The inherent conflict is the governor is the head of the government of the state. That is the ceremonial role of the governor. In that sense, the governor is an essential part, according to the Constitution, of the administration of the state. However, these governors are appointed by the union government, and constitutionally, they have no allegiance to the government of India other than the fact that they are appointed by it. So we have a basic problem in the role of governor in this Constitution, because the appointment comes by somebody, but your loyalty and your role is to somebody else. That is how the Constitution has designed the role of governor. So this is pointed out in this Poonchi Commission report, and it says, the governor is not amenable to the directions of the union government, nor does the Constitution make him accountable to the centre for the manner in which he carries out his functions and duties. The office of governor is an independent constitutional office. The governor, by virtue of Article 163, however, is bound by the aid and advice of the State Council of Ministers. Therefore, in the event of conflict between the aid and advice of the State Council of Ministers and the dictates of the central government, the scheme of the Constitution indicates that the governor must adhere to the former. Even were he to get different direction from the government of India, his constitutional duty is to adhere to the aid and advice of the Council of Ministers of the state of Tamil Nadu in the case of the governor of Tamil Nadu. The Poonchi Commission also held that when the president puts a bill under cold storage, sometimes for the entire duration of the state legislature, the lack of an executive fiat on time frames leads to an abuse of power. The Commission held that such invasion of powers of the state legislature by the Union Executive, because the President acts on the aid and advice of the Union Council of Ministers, is questionable in the context of the basic feature of the Constitution. In fact, it went one step further and it said, should we look into the suggestions of the National Commission to review the workings of the Constitution, which I said happened in the year 2000 under the NDA government. Now, this is the 2007 Poonchi Commission. The 2007 Commission recommends the 2000 Commission's content. It says, should we carry out a constitutional amendment to delete the framework that allowed the governor to reserve a bill for presidential assent, except in very rare cases. That is, the governor should not even be able to refer it up to the president, which is reiterated. It's a reiteration of the NDA government's National Commission for Review of the Working of the Constitution. And it says, if we cannot do that, in the alternative, it may be more advisable to delete altogether the words in Article 200 empowering the governor to reserve a bill for the consideration of the president, except in the case contemplated by the second proviso to Article 200 and in cases where the Constitution requires him to do so. Such a course would not only strengthen the federal principle, but also would do away with the anomalous situation where under a bill passed by the state legislature can be, and I use the words they have used in brackets, killed by the Union Council of Ministers by advising the President to withhold his assent thereto or just by cold storaging it. In that sense, as I say, the Supreme Court judgment, a judgment for the ages, which I have earlier remarked, is in our era the equivalent of the Kesavananda Bharati judgment or the S.R. Bommai judgment, has covered all these aspects and has now come out with a very clear judgment, incorporating timelines recommended as far ago as the Sarkaria Commission in 1983, recommended and set up by the government of India, not by the government of Tamil Nadu, right? So, in this context, right now, I would say the formation of this committee that the Honorable Chief Minister has announced yesterday is in a direct response to the current circumstances. One, of course, the judgment being the immediate context, but two, the overarching authoritarian move of the government of India to centralize all aspects of governance, of finance, of items, whether they are in the concurrent list or the state list, not just in the union list of Schedule 7, into their ambit and to legislate on things that are clearly in the state and concurrent lists without any consultation with the states. This is a mandate to this committee to examine the constitutional provisions that affect state autonomy, and it is aimed at benefiting the notion of federalism in all states and not just the state of Tamil Nadu. For example, the chairman is actually from Kerala. The committee's composition, as you know, I've already spoken about, and the timeline is that they will submit an interim report by January and a final report within 2 years. Now, it is important to note that much of the fight for federalism, if you look back, has stayed unfulfilled in its ambition, irrespective of who comes to power. I've said this in the union government. I've said it before. I've said it in many articles in the Indian Express, in Outlook India. More than political ideology, this notion of centralizing power in Delhi and centralizing all administration in Delhi is a tendency that happens to whoever happens to sit in office, particularly if they are simple majority governments. Um, it is worth noting, I think, that the Rajamanar committee was more than 50 years ago. The report was tabled 50 years ago this month. But the committee is probably 55 years ago, 56 years ago, from 1969. And yet these issues persist. It is not about which party. If you remember, at that time it was a different party in office in Delhi. It is a different party now. And so consistency is the hallmark of our character, of our political ideology. We have stayed true to these issues irrespective of who is in our coalition, irrespective of which party is running the government in Delhi. Uh, to the contrary, the current administration in Delhi, when this Honorable Chief Minister was the Honorable Chief Minister of Gujarat, when this Honorable Prime Minister of India today was the Honorable Chief Minister of Gujarat, there had never been a greater proponent of state autonomy, federalism, and states' rights than that government and that Chief Minister in recent times. Of course, the legacy goes back for us from 1969. This particular party did not exist at that time and did not have a state government at that time. So our history and our legacy is longer, but their ferocity of the fight, of the challenge was second to none when they were running the government for 13 years. And now that they have been running the union government for about 11 years, suddenly they have turned 180 degrees and are exactly opposing the very statements and the very intent and the very ideology and philosophy that this Honorable Chief Minister so vociferously fought for in that stage. In that sense, I would say that the areas of concern that the Honorable Chief Minister has highlighted in his speech yesterday, that is to bring back education into the state list, to remove aberrations such as NEET, where the government of India gets to dictate to the states who run their own state medical colleges with their own money and their own setup how there should be a union exam. And then we find so many problems with the notion of union exams, as you've seen all the scams and the scandals associated with NEET. But also, particularly in the area of finance, where the government of India has started to put a lot more of the financial ambit into its purview and do things which are patently illegitimate, like withholding funds passed in the appropriation bill by citing extraneous conditions not contained in the bill, such as you have to do NEP or you won't get SSA funds, etc. And also in the era of GST, where the states have lost a lot of their fiscal flexibility to raise their revenues. So I think it is high time. In fact, one could argue that though this is the attempt after 60s twice, 80s once, 2000s twice, this is the sixth attempt. In some sense, it is more urgent than ever before because we have seen issues arise like never before. And therefore, this is a commission not for the people of Tamil Nadu or the state of Tamil Nadu alone. It is for all of the states of India and therefore for all of the people of India to suggest a better working model going forward in light of the Supreme Court judgment of April 8, 2025.